In 1998, two events occurred, two very tragic events that have reshaped federal criminal law. Specifically, in Jasper, Texas, James Byrd was dragged behind a pickup truck to his death solely because of his race. The same year, Matthew Shepard, who was alleged to be gay, was tied to a fence and tortured and murdered because of his sexual orientation.
This afternoon I signed into law the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act.
As a result, in 2009, Congress passed a federal hate crime law, and it makes it a federal crime to harm somebody based upon their race, their religion, their national origin, their sexual orientation, or whether they have any disabilities. Many people are not in favor of such laws, and there are several reasons why. First, it was already against the law to commit any of these offenses, and they were being prosecuted at the state level, and successfully so. And a lot of people think that the federal government doesn't have any business butting in to what is traditionally an area controlled by the states, which is the prosecution of state crimes. Second, there is a problem that many people may be, as a result of their beliefs, that it infringes their First Amendment rights, and that they may be prosecuted simply because they have beliefs that, for example, are racist. For example, skinheads. In a case in which I handled in Texas, which was one of the first cases involving the federal hate crime statute, several skinheads were prosecuted under the federal hate crime law because they had tattoos on them and because they had beliefs that were associated with racism. Yet there was very little evidence that the assault was actually motivated because of race. It's for this reason, among others, that a lot of people think that the federal hate crime law should not be utilized except for in very extreme circumstances. There are also some serious questions regarding the constitutionality of the federal hate crime statute that have not been addressed yet by the United States Supreme Court. Specifically, the rights to prosecute criminal activities are normally reserved to the states, and there has to be some federal connection, or what is called a nexus, to enable the federal government to prosecute a crime. Now, the federal government's always been able to prosecute acts when they can bring in the Commerce Clause. That is, people are traveling in interstate commerce or it somehow affects interstate commerce. But what is it, for example, about a fight that breaks out between a black person and a white person that has any effect whatsoever on interstate commerce? As a result, the thin reed upon which the federal government bases their jurisdiction is the 13th Amendment of the United States Constitution, which was enacted to do away with slavery and the incidence of slavery. And the government contends that a fight based upon race is an incident of slavery. We will have to await a decision by the United States Supreme Court to determine whether the constitutionality of this statute can be upheld on such a thin reed. If you or somebody you know is accused of a federal hate crime, please contact me. I am one of the few attorneys in this state who has actually tried a federal hate crime case.